let's talk a little bit about the 601A provisional waiver. This is a really exciting new development in immigration law that just passed in March of 2012. Basically, it's just a policy that allows individuals who are immediate relatives of United States citizens and whose only ground of inadmissibility is that they entered the country illegally to apply for benefits in the United States without having to leave the country. In the past, if you entered illegally and you were married to a United States citizen, your only option was to return to your home country and try to consular process through the embassy or consulate in your home country. You had to submit your waiver of inadmissibility there. And this was very risky for a lot of families because sometimes it would take years for these things to be approved. So it was a great risk that a lot of people didn't take. With the new 601A waiver, people can submit the applications here in the United States and get a decision on the waiver before they ever leave the country. This is a great benefit because you're not going to leave the country unless you know that your application has been approved. You still do have to leave and attend an interview at the foreign consulate, but it will be for a pre-scheduled date, and so usually the time that you'll be out of the country will only be around a week. Individuals who are applying for the 601A waiver will still have to prove that their United States citizen relative will suffer extreme and unusual hardship if the family member is not allowed to live here with them in the United States, or if the United States citizen were forced to relocate to the home country. However, the process is expedited here in the United States and it eliminates a lot of the risk for families. So hopefully there will be thousands of people that did not apply before who will be willing to apply now. One of the questions that I am asked a lot about the 601A provisional waiver is whether or not people are placing themselves at risk of deportation if their application is denied. Fortunately, the answer to this is no. The government has stated that if you are not otherwise an enforcement priority, so if you do not have a serious criminal record, and if you do not have a history of immigration violations, such as prior orders of deportation, then they will not place you into deportation proceedings just because the application is denied. So it's really not much of a risk for most families.